moving on for now, the Supreme Court has issued a series of directives to both union government and all state and union territory governments to ensure the effective enforcement of the Prevention of Sexual Harassment at Workplace, also known as the POSH Act. Now, a pivotal directive mandates the appointment of a district officer by the states and union territories under Section 5 of the POSH Act, though the Act only says that the government may do so, but does not cite it as mandatory. However, the court, considering it a mandatory condition, stated that treating it as just a directory would undermine the legislation's well-defined workflow as well as redressal mechanism. The directives stem from a writ petition filed by the Initiatives for Inclusion Foundation to enhance the POSH Act's implementation. Well, I will be joined by my colleague Harish on this very important story. Harish, there is pressure now. There is a stringent POSH Act implementation drive that seems to have started.
Yes, that's right. The Supreme Court has said that center and states should ensure that the prevention of sexual harassment at workplace rules under the Vishaka guidelines should be strictly implemented in all the institutions across the country, and has clearly earmarked a specific hierarchy as per which it is to be implemented. It has said that states and UTs must notify district officers under the Prevention of Sexual Harassment Act, and Supreme Court has issued a slew of directions to the union government and all state UT governments to ensure the effective implementation of the provisions of the Sexual Harassment at Workplace Act. Significant among them is the mandatory direction issued by the court that states and union territories must appoint a district officer as per Section 5 of the Act. Though Section 5 says that appropriate government may notify a district magistrate or additional district magistrate or the collector or deputy collector as the district officer, the court read this as a mandatory condition, and it went on to say treating Section 5 as directory would leave a gaping hole in the otherwise clearly de-alienated workflow and redressal mechanism, and the efficacy of this legislation as a result falls flat. This is the observation of the bench. The bench passed these directions in a writ petition filed under Article 32 of the Indian Constitution by an organization named Initiatives for Inclusion Foundation, seeking effective implementation of the provisions of the POSH Act. So, a big intervention coming in from the Supreme Court to ensure that women do not face sexual harassment at workplace, and
Right.
the prevention of sexual harassment at workplace under the Vishaka guidelines should be strictly implemented by all institutions across India. Back to you.
Absolutely, Harish. Thank you so much for sharing all those details.